It's a connected.
Item 27, my lord, is a writ appeal by the Coal India Limited, a public sector company. My lord, the single judge has set aside.
Before my learned senior proceeds, I may just bring it to the notice of my lord that the order passed by the learned single judge has been directed to be implemented by the Ministry of Coal, which is the administrative ministry. So whether the appeal filed by the Coal India in the face of that would be maintainable. That is the, my lord, this is the order. After the order passed by the learned single judge, the Ministry of Coal has approached the Department of Public Enterprises to implement the, my lord, order passed by the learned single judge. But
My lords, the Coal India Limited, a public sector company, entered into an agreement with the non-executive employees and arrived at the settlement. The settlement was approved by the Ministry of Coal. However, my lord, it was challenged before the single judge on the ground that the said agreement is contrary to the circular or office memorandum issued by the Department of Public Enterprises way back on 24 November 2017. My lord, this interdepartmental communication, whether a violation of that would give rise to a cause of action, is the most important thing. Besides, my lord, the single judge has set aside the agreement, which was arrived at after 6 rounds of negotiation without hearing all the concerned parties. Only one of the trade union got itself impeded. Otherwise, all other, my lord, signatories to the agreement have not been a party before the single judge. That is the most important thing, my lord. There is a clear violation of natural justice. And the other thing, my lord, if your lordship permit me, I would like to just hand over some list of dates so that that would be easier to make my submissions, my lord. May I hand over the list of dates? My lord, turn to page, my lord, in the print order
37.
at 37. Para 20, my lord. Accordingly, the present petition is allowed. My lord's what it? Accordingly, the present petition is allowed. The impugned approval dated 22/6/2023 stands fast. That is the approval granted by the Coal Ministry to the negotiated settlement arrived between the management of the Coal India and the employees, my lord. The matter is referred to the Department of Public Enterprises. That's a part of the Government of India to take a decision while extending opportunity of hearing to all the concerned, including the petitioners and all the trade unions, which were part of the JBCC, that is Joint Committee, my lord, for negotiation. If DPE ultimately comes to a conclusion that there is no violation of the cabinet decision, the Ministry of Coal shall pass the consequential order regarding the approval of the finalization of pay scales of the non-executive. Let decision in terms of order be taken within 60 days from today. My lord, the difficulty is, my lord, there are two set of employees in the Coal India, executives and non-executives. If the pay scales of the executives, non-executives are increased, how are the executives concerned, my lord? How are they discriminated? They can seek for increase of their pay scale. That's a different matter. In the direction is, my lord, the pay scales have been revised. According to the petitioners, my lord, 29 executives who came, they said the highest in the non-executive is higher than the executive scales in E3 grade. That is how they put the grievance. But how is it a grievance? How are they concerned? They can ask for increase of their scales. They cannot say that what is paid to the non-executives by a settlement, by an agreement, which applies throughout the country, my lord, for 280,000 employees are concerned, are covered by this agreement, would be, it would cause any harm to them. In fact, the Coal India has recommended for increase of the scales of the executives. It is not that we are not aware about that. For the interest of the industrial peace, my lord, everything has to be dealt in a harmonious way. In fact, we are recommended for that. Therefore, my lord, there is no ground on which a single judge would have set aside the order. Moreover, my lord, the so-called order of 2017, I will show it to your lordship, that is only a directory. There cannot be a mandatory direction that negotiated settlement should be in a particular way. that would be preempting the free bargain capacity of the trade union and the management. In fact, the cabinet decision, which was taken 2 days before, which is also a part of the record, my lord, or 22nd, says that the management is free to conduct the negotiation. And that is the spirit of the negotiation, my lord. After 6 rounds of talks, something has been entered into, and the government has granted approval. Could it be struck down that there is a circular of another sister department? And 2,80,000 employees are affected by this order, my lord.
On the writ petition. But the submission is, my lords, that's absolutely correct. My lords may kindly have a look on the last paragraph. My lords have seen that paragraph 20 minutes. The learned single judge has only directed the DP, that is the Department of Public Enterprises, who had issued a circular based on the decision of the cabinet. And in that circular, my lord, in fact, if my lords may kindly have a look on the order passed by the learned single judge, that is on page 33, my lords, page 33 onwards. The Coal India, my lord, while recommending, they misrepresented the fact that has come in the, my lord, letter of the administrative ministry. The administrative ministry, while, my lord, seeking implementation of the order passed by the learned single judge, has very specifically said in that letter that there was a misrepresentation by the Coal India with regard to the status of the employees. And therefore, my lord, Ministry of Coal was led to pass an order giving approval to those pay scales. Now, when those pay scales were found to be in conflict with the cabinet decision, my lords, and also the circular issued by the Department of Public Enterprises, therefore, the learned single judge has directed the my lord, Department of Public Enterprises to take a final decision in the matter. There is nothing, my lord, there is nothing. It has been quashed for the time being because it has been sent to the DP. And my lord, the DP, this letter says, if my lord, I may just show this letter to your lordship. This is a letter issued after the
I have something to say on this also.
after the
Could not have
order
been sent to
passed
the
by the
DP.
learned single judge. And if
Concerned
my lords,
is for this.
my lords may just kindly have a look on this letter. This is letter dated 19 September 2023. And this letter reads, now the undersigned is directed to refer to the captioned matter filed before the Honorable High Court of Madhya Pradesh at Jabalpur, Union of India, Ministry of Coal, has been arrayed as a respondent number 1, DP as respondent number 2, Coal India as respondent number 3, and Director Personnel Coal India Limited as respondent number 4. The petitioners, though, through the instant writ petition, have contended that recently implemented NCWA 11 is in violation of clause 4 and 5 of DP guidelines dated 24/11/2017. It is the case of the petitioners that as per OM dated 24/11/2017, the pay scales of non-executive employees cannot be higher than the executive employees. Now they say, now the Coal India Limited, respondent number 3 and 4 has misrepresented the respondent herein, Ministry of Coal, due to which the NCWA 11 has been confirmed by the ministry. Matter was heard by the Honorable High Court on 29/8/2023. The Honorable Court reserved the order and the same was uploaded on the website on 8/9/2023. The Honorable High Court has allowed the petition and Ministry of Coal's approval dated 22/6/2023 stands quashed. As directed by the Honorable High Court, the matter is referred to DP to take decision. So as far as the administrative ministry is concerned, they have already sent it for the implementation. And how the Coal India can have a different stand than by, my lord, from the stand of the their administration. No, follows may not, my lord, I'm
No,
not.
this is-
My lord, I'm only on the question of interim, my lord, that interim may not be granted.
Otherwise, employees-
My lords may hear us on an early date. But then
So the salaries
by
are not-
these crores of rupees, now they will, no, salary are, my lord, it's their own volition. The court has never stated that part of salary. Now they are, my lord, insisting, despite the questioning of this NCWA 11, they are insisting to, my lord, to grant the pay at this quest, my lord, NCWA 11.
No, once
They may
quest-
pay the salary at NCWA 10, my lord, we have no objection. And in fact, they have stopped our salary also, my lord. And my lord, the union, my lord, which are here, the union is creating a, my lord, the law and order situation there, my lord, the slogans are being chanted against, my lord, against these officers who are the petitioners. They are with the, my lord, life threat. Our salary without any, even salary of whether executive or non-executive could not have been stopped. The court has quashed NCWA 11, my lord. Prior to, my lord, the management.
So, my lord, once the order has been struck down, my lord, we have no authority to pay as per the revised scales. That's how it is stopped.
For the last 2 months, my lord, we are paying the revised scales.
We have paid the revised salary till September, my lord. Once the order was uploaded, for the month of October, it has been held up now.
As per the new revised way.
My lord, may kindly see, there are two, my lord, my submission is this. The salary of non-executive was being paid at, under, my lord, NCWA 10. Prior to this, NCWA 11 came into effect. My lord, our salary, we are the executive, we are the petitioners. Our salary, my lord, they have stopped, my lord, our
Their salary
salary
is not been stopped.
is, no, our salary has been stopped as a revenge, my lord. Or we did not receive our salary for the last month, this month. Yes. My lord, as far as our salary is concerned, but our
Both, my
salary,
lord,
as far as, my lord,
executive and non-executive, both salaries have been
Lord,
stopped.
what
Your
my-
lordship clarify.
my lords may kindly, my lords, my submission is this, my lord, their salary, they may pay under NCWA 10, because NCWA 11. My lords.
Both the categories. Both the categories.
Yes, prior to, my lord, this litigation. Yes.
My lord.
Yes, prior to this,
September, what we paid for September will continue with October.
prior to this, my lord, order. But that is, my lord, the prior to litigation.
Till September.
Salary, my lord, they
Till
cannot.
September, we have paid. Till September, it is paid. We continue
But
the
then,
same
my lord,
as was paid during the last
my
month.
lord, in the month of September, my lords, I may clarify, my lord, because in the month of, my lord, till the month of August, the salary was being paid as NCWA 10 months. They implemented this NCWA 11 in the month of September. Now they intend to pay the salary at the NCWA 11, which has been quashed. So my submission is they may pay the salary at the rate which was prevalent under NCWA August.
No, my lord, on the revised scale, we already.
Otherwise, my lord,
salary, my lord.
it will
We have
amount
paid the
to.
salary for 2 months, we have paid the arrears since 2021. My lord, we have to continue to pay that salary. Otherwise, there will be industrial unrest.
No, where is the question of?
Right. Fair enough.
We'll
Well,
pay
that,
that.
that will amount to, my lord, staying the operation of the
What
order.
is being done? That is what is
My
being
lord,
done.
my submission is the, my lords may, my lord, my submission is, my lords may hear us on an, my lords may kindly see. Correct, my lord. My lord, out of 60 days granted by the learned single judge to DPE, my lord, 40 days have already passed. It's only the 20 days. So my submission is, my lords, may kindly, my lord, wait for at least, my lord, for 20 days that interim order may not be passed. My lord.
I don't know why is he against my salary, my
No,
lord.
that's not the question.
Of course you are against.
No, today,
Petitioners don't.
Then
stand
what does it false
They
here?
belong to executive caste.
And he has unnecessarily questioned my salary and getting himself into trouble.
Appellants,
Coal India Limited.
Coal Indian appellants, my lord. We are appearing together for all three appellants.
my lord, I am for the, my lord, response number 1 to 1 to 29 minutes. 29 minutes.
Mr. Yadav is.
But I appear for northern coalfields, which is in Madhya Pradesh, at
Well, I appear for the appellantly connected. That's my appeal. I think Khadan Majdoor Sahab. I agree with that. All of these.
My lord.
Coal India.
We are appearing now.
northern coalfields 33 I'm appearing, northern coalfields.
My lord, may,
September. My lord.
I'll send the,
And non-executive,
Non-executive, both categories.
Executive and non-executive.
both.
Non-executive.
Executive.
My lord.
may I make a submission? My lord? May I make a submission? This response number 32. This 32 model Hind Khadan Mazdoor, this is a union models. Now this union is creating a problem for these executives who are petitioners model, because they led this model, they filed this petition, and on their petition this NCWA 11 was quashed. They are creating model, the difficulty for these. They are model, shouting slogans against them in front of their houses. They are model, burning the effigies in front of their houses, and they have created model, difficulties for these executives to come out of their houses. They are model, at the NCL.
How effective is that?
We'll take steps for maintaining the industrial harmony, my lord.
You are not doing that. Coal India
We'll
is
do
not doing that.
We'll assure the court, my lord. We'll assure your lordship, we'll take steps to maintain industrial harmony, my lord.
We are
Yes.
executives, yes. Or we are not able to come out of our houses because of the threats.
Steps will be taken for maintaining industrial harmony, my lord. Obliged, ma'am.
Or some early date we find in. Some of so only my lord, very.
After 6 months, you'll get them both.
In fact, my lord, probably my lord, I could not.
I don't know why
They
he's so
basic,
concerned.
my lord, they want an
Probably-
increase of this.
I could not put it correctly, my lord, I may just clarify.
He should concentrate on revising his salaries, my lord.
I'm
Not-
grateful.
This litigation, they will have a higher.
But I may just clarify, my lord, that Now, this NCWA is with regard to the non-executive pay scales. We are executives. Our pay scales ought not to have been, our salary ought not to have been affected by this.
How is it
Because,
affected, my lord?
Now,
Will also get the revised one.
He is not reduced.